I received several calls, and I've seen reports accusing Secretary of State Ritchie of actively campaigning against the voter ID amendment. And as the Secretary of State falls under the jurisdiction, members of this committee, I felt it was our duty to investigate these allegations and claims further in a very transparent way.
The question that comes to mind for me is, number one, how many different cities did Secretary of State Ritchie visit? And is what he is doing, is it part of his official duties as a Secretary of State? Now, unfortunately, again, he's not here and we can't ask him those questions. But I believe that his legal responsibility is to implement the laws that involve elections that the legislature passes. I do not believe that it is within his responsibility as a constitutionally elected officer to travel around the state and be a proponent or an opponent. So I think the question becomes, for purposes of this portion of the hearings, is it a violation of his oath of office to travel around the state being an opponent to a piece of legislation on elections that the legislature voted? Should the taxpayers of the state of Minnesota be responsible for footing the bill? Presumably, he has to get there somehow. And if he's doing it during office hours, during normal office hours, he's on or being paid in his salary his official duties as Secretary of State, and yet he is being an opponent of a piece of legislation that we passed.
Just to follow up on what you just said, Senator, is I believe everyone has this in their folder, a letter from the Secretary of State to Chief Justice Gilday. If not, I will go through it for you. The Secretary of State makes note here that I have the ministerial duty to ensure that the ballots are properly printed, not to take a side as to whether a ballot question proposed by the legislature accurately or completely represents a constitutional amendment under consideration. Senator Gazelka, to the point.
Yeah, thank you, Mr. Chair. Because as I was reading the letter from Mark Ritchie to Judge Gildia, the third part I would say in there is he's acknowledging that it's not his responsibility to take a position, which tells me that he must have some knowledge of these statutes about what his responsibility is. And under 211B.06, where it talks about with respect to a ballot question, promote or defeat, if it's false or the person knows it's false, communicates to others with reckless disregard. Well, I was reading I think it's in everybody's packet, the KAAL-TV interview about 4 paragraphs down. He says, Mark Ritchie, the Secretary of State, says, the amendment would also eliminate the state's ability to do same-day registration as well as complicate absentee ballots. This amendment never eliminated same-day registration, so that is misleading, and so that's where I can see he's clearly out of bounds on what his authority is here.
The Secretary of State has the right of freedom of speech. I've heard this come up in this committee, that he has a responsibility to accurately describe our election process, to answer questions about constitutional amendments, anything that's going to be on the ballot, our election procedures. But in Minnesota, there's a campaign finance law where if you're going to advocate for or against a ballot question, you're required to file a ballot committee, which we have done. Now, I don't think that anyone here would say that in the United States some people are more equal than others. The First Amendment applies equally to all people, but the state of Minnesota requires this filing of expense reporting and revenue reporting if you're going to advocate for or against a constitutional amendment. So I'm here today to express concerns about the recent actions and statements of the Secretary of State and his staff. Based on my observations, news reporting, and things that I've been told by other people, eyewitnesses, I'm concerned that the Secretary of State is using his position of public trust to advance a political agenda rather than impartially administering the duties of his office. Senator Newman mentioned some of these instances. I'm concerned that taxpayer resources may be being used for political purposes, specifically to campaign against and spread misinformation about the voter ID amendment. Since this legislature passed the voter ID amendment, the Secretary of State and his staff have been traveling the state making claims about the impacts of the voter ID amendment that are demonstrably false. For example, in op-eds and media interviews, the Secretary of State has repeatedly claimed that some elderly people, especially older women, will be disenfranchised by voter ID because they can, quote, never get an ID, because they may lack certain vital documents required by the Department of Public Safety. This is demonstrably false. The Department of Public Safety has a variance process for people missing vital documents like birth certificates or a marriage license. It involves a one-page form to be submitted with the application for identification. The Secretary of State has claimed that if the voter ID amendment is adopted by the people, it can't be changed and will be in the Constitution forever. This is obviously false. If the Constitution were impossible to amend, we would not even be here today. The Secretary of State has claimed that provisional ballots are a nightmare and chaos in every other state that uses them. They're employed by 44 other states. We're one of only 6 that don't. Are we to believe that elections in all but 6 states are nightmarish chaos? The Secretary has claimed that provisional ballots will delay election results, which is also demonstrably false. Indiana has a similar voter ID law to our proposed constitutional amendment. Their voting population is similar to Minnesota's. In the high turnout election of 2008, Indiana had fewer than 4,000 provisional ballots cast. Superimpose that onto Minnesota's 4,000 voting precincts, approximately, you're looking at an average of less than 1 provisional ballot per precinct. Any election that could be decided by such a small number of votes would trigger Minnesota's mandatory recount laws, which take far longer than certifying and counting provisional ballots. Therefore, provisional ballots cannot delay election results. The Secretary of State has repeatedly claimed the voter ID amendment will eliminate election day registration, which is impossible. The voter ID amendment doesn't say anything about election day registration. Election day registration is a matter of current statute, and in order to change that, it would require a statutory bill passed by this legislature and signed by the governor. Unless the Secretary believes that Governor Dayton wants to eliminate election day registration, which he's on record as saying he does not, it's obvious that that's not going to happen. Secretary Ritchie has claimed that deployed military voters will be unable to vote as a result of the voter ID amendment. As the state's chief election official, one might expect that he'd be aware of the Federal Uniformed and Overseas Citizens Absentee Voting Act, also known as UOCAVA, and MOVE Act. Military absentee voting is governed by federal law, and no state law, not even a constitutional amendment, can override that federal process. This is another demonstrable falsehood. I mentioned the Secretary's repeated false statements to demonstrate that he is not merely providing voters and election officials information about the voter ID amendment, but has clearly crossed the line into actively campaigning against the amendment. Minnesota majority and several lawmakers have filed suit against Ritchie for his attempt to change the title of the voter ID amendment from the clear and obvious language, photo identification required to vote, to changes to in-person and absentee voting and voter registration provisional ballots. This new title doesn't even contain the words photo ID, which is what voters interested in the issue will be looking for on the ballot. This appears to be nothing but a cynical, biased, and hyper-partisan ploy to suppress affirmative votes for the amendment by creating voter confusion. This is a matter that will ultimately be settled by the Minnesota Supreme Court, but I mention it as another example of how I believe the Secretary of State is misusing his position of public trust and his office. The Secretary of State has deployed his staff across the state conducting what are ostensibly training sessions for local election officials. According to news reports and eyewitnesses, a significant part of that training has involved the same kinds of information about the voter ID amendment. Why do election officials working on the 2012 election need training on voter ID when, if ratified, the voter ID amendment won't take effect until July of 2013? I have 2 major concerns that I believe this committee should investigate. First, the Secretary of State appears to be actively campaigning against the voter ID amendment. I believe he may be required to form a ballot committee and report all expenditures and sources of revenue in his campaign. He has not done so and may be in violation of Minnesota campaign finance law. Second, it appears the Secretary of State may be using taxpayer resources to campaign against the voter ID amendment, which I'm quite certain is illegal. I recall the Secretary of State has run into trouble for this sort of thing before. It's my hope that this committee will fully investigate the actions of the Secretary of State, including a review of his calendar and expense reimbursements, the calendars and expense reimbursements of all employees in the office, whether the Secretary was required to form a ballot committee, and whether he has used state resources in a political campaign.
I do have a question for Mr. McGrath, and you may or may not know this. My research shows that in Minnesota, the Secretary of State has never changed a title to an amendment that was adopted by the legislative bodies. Can you verify that? If not, I'm going to ask whoever the representative is for the Secretary of State. But I don't think there ever has been one where the Secretary of State arbitrarily changed a title, and in this case made them very unclear.
Mr. McGrath?
Mr. Chair, Senator Gazelka, our legal counsel has investigated this issue in the title lawsuit that we've launched this week, and the information that you have is accurate.
I'm referring to a column that appeared in the Pioneer Press, and it refers to the change in title that we are discussing today. Changes to in-person and absentee voter and voter registration provisional ballots. Ritchie, who is well-read and well-spoken, clearly had to go deep into the Orwellian playbook to come up with that one. It is a bizarre formulation and obviously seeks to obscure the initiative and confuse the voter. What we're talking about in this amendment is that voters have the ability to vote and have their vote count. It feels to me like what Secretary Ritchie has done is he has tried to, in fact, suppress the vote by selecting a title that obscures what the amendment is trying to achieve.
There are very few things where the legislature can act without a signature from the governor. Constitutional amendments is one area in which the Constitution allows us to do that. And when you've got a case out there, the Stearns case, that says that part of the constitutional directive to the legislature is to direct the manner in which the ballot measure is presented to the people, there is no, in my view, legal reason, obviously, for the Secretary of State to change this. And I would submit that there is only one reason to not accept the title from the legislature, and that is that the Secretary of State, who has made his position on this issue very clear, nobody can deny that the Secretary of State opposes this photo ID amendment, is changing the title in a way to help his side of the issue succeed. We in Minnesota have a right to expect better. Yes, there are partisan elections for constitutional officers, Secretary of State, Attorney General, etc. But once those people are placed in their roles, whether Democrat or Republican, they have a duty to serve all the citizens of the state of Minnesota, and to use Secretary Ritchie's own words in his letter to Chief Justice Gilday, perform the ministerial function. Our Secretary of State has crossed the line in this particular instance and is being a partisan. And that is something that Minnesotans should not be happy about.
I would just like to end with a final comment. I am deeply disappointed that Secretary Ritchie and Attorney General Lori Swanson did not fulfill what I believe is their obligation to sit before the citizens of this state and answer questions. I am disappointed. I've always believed that they are better people than what they showed us today. My next action, whether it is to move forward and continue this investigation and look, will be made soon. And that could include different avenues. I will still take written testimony if somebody would like to submit, and will be in the minutes. As to the accusations, I believe there are still folks willing to come forward. I believe this committee hearing will open the door to that. I believe we will hear more from election judges and those who have sat in front of the Secretary of State and his staff. I believe now they understand that there is a belief that he is overstepping his bounds. I'm concerned that the Attorney General is not representing the Secretary of State, which I believe is also extra cost to the citizens of the state. And this is a serious matter. And we need to continue to address it and follow it. And with open transparency, which I believe this committee has done today.